Hello everyone, my name is Ryan Macias and the court case I will be discussing today is the University of California Regents versus Bakke. This was a Supreme Court case decided June 28, 1978, and it is fascinating because it centers on issues of desegregation and the difficulties integration presented after the passing of the Civil Rights Act of 1964. Even further, the case sheds light on the impact of the Equal Protection Clause stated in the 14th Amendment. That clause reads, "No person in the United States shall, on the grounds of race, color, or national origin, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance." This clause will be important to understanding how this case had such an impact on desegregation in education. Our story begins with the University of California Davis's medical program, which had what they deemed a special admissions program created for minority students interested in the medical field. UC Davis later states their goal for the program was to train medical staff to serve minority populations of the time. Essentially, Davis, which had recently upped its entire medical program's enrollment from 50 to 100 students, set aside 16 of the 100 spots specifically for minorities going through their special admissions program. The individuals enrolled in the minority program did not have to meet the requirements required for general admission into Davis, such as a minimum 2.5 GPA, a high score on the medical college admissions test, and high benchmark scores from their admissions committee. So where does Alan Bakke fit into all this? Bakke was a white man who applied to UC Davis's medical program in 1973, but was rejected despite a strong benchmark score of 468 out of 500, successful interview with the admission committee, and great test scores. Though he did apply late in the year, and no students were accepted with a benchmark score lower than 470 by the time he completed his application. He barely missed the cut. Now, Bakke was aware that not only were spots available for the special admissions program, but also individuals in the program were accepted with scores much lower than his. In response, Bakke wrote the dean of the admissions committee to protest that the special admissions program was operated as a racial and ethnic quota. Unfortunately for Bakke, the dean performed his faculty interview in 1974 when he had his second attempt at entering the program. Consequently, he received a much worse profile than the year before. He still obtained very competitive scores on his benchmark, yet he was once again rejected from Davis. And once again, he was not put on the wait list, or in other words, not recommended for the special admissions program. At this point, Bakke filed an instant suit in the Superior Court of California. He alleged that not only did the school violate the Equal Protections Clause of the 14th Amendment, but he sought mandatory relief, compelling his admission to the medical school. For our purposes, we will be mainly focusing on the former allegation. When the Superior Court of California heard Bakke's case, they found the special program did, in fact, operate as a racial quota. This was because, importantly, minority applicants in the program were only rated against one another, not against applicants as a whole. Essentially, under any circumstance, there would always be 16 minorities in the class of 100 medical students each year. It is important to note here that there were minorities who were accepted into the program through general admissions, but no matter what, there would always be those 16 spots. That was the biggest issue the court had with Davis. In addition to ruling that Davis's program was unlawful, the Superior Court also declared that the university could no longer take race into consideration in admissions. And by the way, they told Bakke that he did not carry his burden of proving that he would have been admitted, but for the existence of the special program, so he was not admitted. After these rulings, both parties appealed their portions of the case, and the Supreme Court of California transferred the case directly from trial court. The Supreme Court now had to answer a big question that centers on the issue of desegregation. Should race be taken into consideration during university admissions? Their answer was that they agreed that Davis's goals of integrating the medical profession and increasing the number of doctors willing to serve members of minority populations was important, but the minority admissions program at UC Davis was not the, quote, least intrusive means of achieving those goals. The justices sought to make the point that yes, while the university violated equal protections laws by rejecting Bakke and not placing him in the special admissions process, their end goal was something that they could agree with. The Supreme Court decided that the main issue was the quota for a particular amount of minorities to be accepted into the program, and that was the intrusive part of their actions. For this reason, they reversed the superior or lower court's ruling to prohibit taking race into account during admissions. This has a big impact on education because the Supreme Court is saying yes, consideration of one's race and ethnicity is important to the issue of desegregation for minorities' sake. Yet schools cannot simply say, we have met our quota, and call themselves integrated. The ruling highlights that it is important to look at race and ethnicity as one element of an individual's many characteristics. Schools during the years after the Civil Rights Act needed some way to figure out how desegregation would reach all corners of the country. And this was a difficult task, especially in highly professional areas like the medical field. Throughout the country, people were being asked to begin looking at minorities as individuals with multiple talents, complex individuals that had much more to their character than being Black, Hispanic, or Asian. This was a much larger undertaking than simply reaching a quota that absolves schools from further scrutiny. So it makes sense that we would need the Supreme Court to continue to look at and scrutinize cases like this. For students today, the impact is immense because although there are still schools that are homogenous, institutions all over the country are much more diverse. Many students are able to enter schools with a sense that no matter their ethnic or racial background, the other elements of their character can speak out and show teachers, counselors, and administrators what they really have to offer as students. I personally agree with the court's decision to not only deem Davis's admission program unlawful, but also to reverse the original ruling that prohibited taking race into account during admissions. Race and ethnicity can be a powerful tool to understanding an individual and open doors to finding out more about their talents and personality. Our background is something we can't deny or hide, so it is an important part of life to share with others and bring them closer to us. Learning more about this case helped me see the importance of embracing differences and diversity in order to understand how each of our personal characteristics helps build our individuality. Essentially, denying or pushing our differences under the rug makes it more difficult for us to become closer and learn from one another. And by the way, the Supreme Court did compel UC Davis to admit Bakke after all. Thank you for listening. I'm Ryan Macias, and have a great day.